Good evening and welcome once again to another program of Issues in the News, where we discuss the important events that would have taken place in Guyana over the past week or so. And I want to begin by welcoming our viewers who are joining us on television from region number 5, Mahaika to West Coast Berbice. Welcome to another program of Issues in the News. To our viewers who are joining us on television across the Berbice River, on the east bank of Berbice and New Amsterdam, Kanji, and along the Quarantine Coast. All of you who are joining us on television, welcome to another program of Issues in the News. To our listeners and viewers who are joining us from Freedom Radio at Rob Street, Georgetown, welcome to another program of Issues in the News. And last but not least, to the hundreds, thousands of you who are joining us across Guyana on Facebook Live, across the Caribbean, across North America, across Europe, and even across Asia and further afield. All of you who are joining us on the Facebook platform and on YouTube, welcome to another program of Issues in the News. And I see that hundreds of you have already joined on. Sally Jones, Kev Samaru, Clarice Har, Mala Ramnaut, Naraindat Sharma, Omar Sharif, Fred Ramlagan, Ahmad Ali from Toronto, Vivek Pandey, Lennox Dayal, and so many of you, Sally Jones, Stanley Hamilton, Bibi Ali, all of you, welcome to another program of Issues in the News. And of course, please share this program. Press the share button on your phone, on your iPad, on your internet, on your computer, whatever device that you are using to view this program. Please share it so that all your followers and all your friends and all the persons on your feed can join in the program so that we can have the widest possible audience. Again, please share the program, press that share button on your phone so that as many persons as possible can join our tonight's discussion. We have some very important issue that I would like to address. Noradeen Khan, Bola Premchand, Deonan Alfred, Anand Kumar, Pam Singh, welcome once again to another program of Issues in the News. And please, if you want me to address any issue, you can type it in there and I will read your views and I will try to address it. As I said, I would like to make this program as interactive and as engaging as possible so that it is not a monologue. I want it to be more than a monologue. I want it to be an interactive session. Members of the press have been asking me to convert at least one session of the program at periodic intervals into a news conference where I will invite and take questions randomly from members of the media. I don't have any difficulty with that, and I've asked my operator to begin to devise a platform and the necessary arrangements to allow that to happen. All I worry about is whether I will have 1 hour of material from the reporters. You know, sometimes I go for an hour live and I get 5 questions. And, 5 questions, I can dispose of that in far less than an hour, depending, of course, on the questions. So, to the press, I am saying that I will do that. I will accede to that request to convert one of these sessions at periodic intervals into an engagement where I will exclusively dedicate the session to answer whatever questions the press may direct at me. Of course, I would sincerely hope that the questions would be directed to my sector so that I don't have to speak outside of my portfolio and trespass upon the functional province of any of my colleague any of my colleagues in government. I don't like to do that. I prefer to answer questions that are within my functional remit. Not that I can't answer for anyone, but I'd prefer to operate within the four corners of my ministerial portfolio. So I just thought that I would put that out there. But to the particular journalist who has been asking that question, I am answering it in the affirmative, and the arrangements will be put in place for us to have an exclusive engagement with media operators in Guyana. Having said that, yesterday I attended a ceremony whereby His Excellency the President, Dr. Mohabir swore in the mayors and deputy mayors who were elected at the recently held, or as a result of the recently held local government elections. I want to take this opportunity to extend hearty congratulations to all the mayors and deputy mayors of the various town councils across the country. I believe there are 10 municipalities across this land, and the mayors and deputy mayors of those municipalities took their oath of office before His Excellency President Dr. Mohamed Irfan Ali at the Arthur Chang Convention Center. Yesterday, I was privileged to be present, and I want to extend to all of them my sincere congratulations. I hope that they will give effect to that oath that they took, and I hope that they will discharge the functions of their office without fear or favor and competently, and they will not be swayed by political interests, but will be guided by the paramount consideration of the people's interest. So I just want to begin by echoing those sentiments. Tomorrow we have another sitting of the National Assembly at which some important pieces of legislation would be debated and hopefully passed. Tomorrow we will be debating the Petroleum Activities Bill, the Data Protection Bill, and the Digital Identity Card Bill, three very important pieces of legislation. The Petroleum Activities Bill, that obviously deals with the petroleum sector. It seeks to repeal the current legislation, the Petroleum Production Act, which is a 1986 law enacted at a time when we were a radically different place, when the industry was a radically different industry. We were not a oil and gas producer. We did not have any verifiable or verified reserves in any appreciable quantity. Things are fundamentally different now. Guyana is an oil producer. We have billions, over 11 billion barrels of reserves, valued several trillion United States dollars. We are producing at a rate of approximately nearly 150 to 200,000 barrels per day, and that is scheduled to increase astronomically within the next 5 to 7 or 8 years. We are destined to be one of the largest producer of crude, not only in this hemisphere, but across the globe, if all the projections are to come to pass. We have major operators now in the sector. We have major operators trying to get into the sector. The sector has kicked off and is one of the great trigger of economic and commercial activities in Guyana, and has contributed significantly to the transformation that is permeating this land: physical, economic, social, and commercial transformation. So the environment now, the country now, the economy now is a fundamentally and radically different one than that which existed in 1986 when the current law was promulgated. And therefore, the time is now ripe for a new, comprehensive, modern, industry-driven, industry-tailored, realistic law to be implemented. In the government's view, the Petroleum Activities Bill qualifies as the law for this period. No law is crafted in stone, but it is expected to be the governing framework that will lead the industry at least over the next 5 to 10 years. There are many oil blocks that will be auctioned shortly. We have put out in the public domain draft profit-sharing agreements that will be the framework, contractual framework, that will inform new agreements that are to be executed by impending operators, new operators, and the government of Guyana. And this law will create the legal cradle, will create the legal framework, will be the statutory code by which the industry will be governed, guided, and administered. The laws are appreciably different, qualitatively different in many respects from the current law. I mean the bill. The bill is qualitatively and appreciably different than the current law in many, many, many respects. First of all, it's much more expansive and it covers a wider spectrum of activities in the sector. It deals with a licensing mechanism that is much more expansive and comprehensive, beginning with defining what is oil and gas and vesting the property in that petroleum in the state, and then it begins to speak about the licensing regime, and it deals with elaborately with exploratory license. The previous act spoke about a prospecting license. Then it outlines how exploratory work or exploratory activities will flow into production, and then it deals with post-production, decommissioning of wells, and so on. So the entire gamut. It doesn't deal with downstream activities, as we are not contemplating at least not for now, downstream activities in the industry and certainly in the bill. So it deals with also who shall qualify to participate in the industry, and the qualifications are adequately set out. It deals with the new tax regime, and it's a tax regime that will see far greater revenue stream than what exists now. VAT, for example, will be applied in a much more broad-based manner and on a level playing field. The previous act, or rather the current act, exempts completely VAT from the industry. That will change. Corporation tax, which was exempted, or which is exempt, will now be leviable at a rate to be determined by the Minister of Finance, and it has already been disclosed publicly that it will be at a rate of 10%. Income tax will now be paid. The royalty regime would be radically different. From 2%, it is now being increased to 15%, and it will be calculated not on 75%. No, sorry, cost oil will shift from 75% to 65%, and then the profit sharing arrangement will come in, and that profit sharing arrangement will be 50-50. Whenever there is royalty owed, or there is any money owed to the government of Guyana, we have a regime that will impose interests on all outstanding payments. Also, there is a fiscal regime in place that will charge a rent, that will charge a training fee, that will charge a contribution to go towards social and environmental activities, and these are running into millions of dollars, and they are not going to be considered as cost oil or costs. So then you have signing bonus are provided for. Importantly, you have public auctions being the main process by which the oil blocks will be disposed of. Only in the rarest of circumstances would the minister be empowered to dispose of oil blocks through direct negotiations, and there are set criteria that must exist. It must be in the national interest, etc., before one can deal directly rather than through a public auction process in relation to oil blocks. The minister's powers in the bill are curtailed in several instances where he's enjoined to act upon the direction or advice of cabinet. So, by and large, it is a modern bill. It has we have drawn from several countries, the United States, the United Kingdom, Canada, Australia, Trinidad and Tobago, and of course, where possible, the certain sections of the old law were retained, where it was found that it still had some utilitarian value. So that's perhaps one of the most significant legislation that our Parliament will enact since independence. So the debate there I suspect is going to be robust, and we welcome robust debate, but I hope that it is constructive. The Data Protection Bill is another signal bill of ours where government again is making a crucial and a gigantic step of converting our government and the way we do business from a manual system to an electronic digital one. This bill will for the first time protect privacy and data, personal data that are collected from citizens. It will regulate how these data will be stored, under what circumstances they are to be accessed, under what circumstances their use can be put, what purpose they can be used for, and an entire governance structure is being established to manage this data collection, storage, use, and processing in the country. Right now, there are data amassed every time in various sectors in the country. Every time you use the internet for the transaction of a personal business, your data is used, your data is exposed, and right now there is absolutely no framework and protective safeguards in relation to what becomes of that data, what use can be put of that data, who can keep that data, where the data is going to be kept. Nothing like that. It's just a free-for-all. For the first time in our country, a governance legal framework, and a legal framework is being established to collect data, store it, and use data for the benefit of the people of our country in making business easy. The third bill is a digital identity card bill. This is another bill that will implement a transformative initiative in our public and private sector. Many countries have already moved in this direction, and they have digital cards that allow digital cards that can be used across various platforms to access various services, both in the public and private sector. It's secure. It has many uses to which it can be put. It reduces cost, and it makes doing business very easy and very convenient. In India, for example, there's the Aadhaar card. In the US, you have the Social Security card. In Canada, you have another set of cards. And these cards, in Guyana, we are using one. This one will have a unique number of yours. It will have certain basic biometric and biographic data of yours. And it will connect systemically with all your information in the public domain. So this is the card you will go up to get your pension book. This is the card that you can go to access your bank account. This is the card that you can go to the public hospital and they will use that card and get into your health records. One card which will be the key to open various cabinets, fictional cabinets of your data being stored in different places. If you go to GRA, this is the card that you will have to show. And once this card is put into the machine, all your tax information will come up. Your TIN number, your driver's license, everything that GRA has on you will be synchronized and will be accessed through this singular medium. So you don't have to walk around with a whole bundle of various cards. One card will be able to access all this information and will be able to enable you, will enable you to transact business right across the length and breadth of Guyana and even overseas if we have a reciprocal agreement with that country in respect of the use of a card of that type. It will also regulate the conduct of foreigners in the country. Like, it will have, if a person who is a non-citizen of Guyana is in Guyana and is working, they will be issued with a work permit card. It's not going to be called a work permit card, but a digital card for persons who are here to work. Of course, CARICOM nationals under the Treaty of Chaguaramas are going to be exempted, but outside of that category, persons will have a card that will enable them to also interact with businesses in Guyana, the public sector and the private sector. It will also document whether they're legal or illegal or how long a work permit has, etc. So once that card is accessed, any person will know, for example, all the details of this individual, which country they're from, where, what are they doing in Guyana, and if their term permitted to be here has expired or is still in force. So that card will be in use, and the law to permit that card to be acceptable as a national form of ID, not to replace our national ID, but as a national form of ID and as a national medium to transact business across the country. This is the law that will give that card the legal and legitimate, the legal potency and legitimacy that will make its use acceptable and mandatory in certain cases. So we have a very packed agenda, and in the Parliament, in the National Assembly tomorrow. And it brings me now to what happened last week in the Parliament. Last week in the Parliament, we had to pass a series of laws, a series of bills that are important rather, to our AML-CFT architecture. Guyanese are now very, very educated in the area of anti-money laundering, countering the financing of terrorism, as we have had some very bad experiences with our inability to pass these laws. And we understand their importance. These are laws that are connected to our international obligations. All countries must pass these laws and must comply with these international obligations, or else their financial systems can be sanctioned, can be blacklisted, and their citizens can face severe consequences. When the APNU AFC had a one-seat majority during the Donald Ramotar presidency, they voted down a number of these bills, and they caused us to be sanctioned. And that's why I'm saying that Guyanese are well acquainted with these laws. Up to now, we are still recovering from those sanctions. The Real Estate Agents and Brokers Bill, the Anti-Money Laundering, Countering the Financing of Terrorism Bill, and the National Compliance Bill were at least three bills that we had on the agenda which were debated and passed. And many of you who would have heard the presentations would have been familiar with what these bills were about and their importance and why we had to pass them, because the explanation came in every bill that we have an impending assessment in September that would be done by the Caribbean Financial Action Task Force of Guyana's financial system. And we have to put all these laws in place to ensure that we pass that examination, or else, again, as I said, we can be sanctioned. What worries me, though, is the level of contribution that the people of Guyana are receiving from the opposition. Now, the opposition in any country is an important component of democracy. In a parliamentary democracy, the opposition is a crucial part of the lawmaking process and of the oversight mechanism that constitutes a vibrant National Assembly or Parliament, if you wish. The Guyana's constitutional structure is no different. But what we have in the National Assembly from the opposition is a group of persons who do not read the bills. They do not prepare. They scramble together night before, or some of them, I'm sure, read the bill on the day while the session is ongoing. Then is when they read it for the first time. And they stand up to speak. And because they have not studied the bill, and because they have no residuary knowledge of the particular area, they make the most outlandish assertions in their presentations. When they decide to speak on the bill, they make outrageous remarks, outrageous assertions. They make nonsensical presentations because they have not read the bill. And I'm saying that the people of Guyana, in particular, supporters of the APNU AFC, deserve better. They deserve a better quality and a higher quality of representation. And because they don't read, because they don't prepare, all of them come with the argument that the bill must go to a select committee. It must go to a select committee not because it warrants going to a select committee, but because they have not prepared, they don't understand what the bill says, so they wanted to go to a select committee to give them more time to read, to give them more time to prepare. Now let me say that the select committee is an important mechanism to scrutinize a bill when scrutiny is required. And our government has a long track record of taking bills to select committee. We took the constitutional reform bill to the select committee. That's an important bill that requires an input from the opposition. I chair that committee. We took it to the select committee. It stayed in the select committee for nearly a year and a half. I had to beg them to attend the committee meetings. When they attended the committee meetings, they are unprepared. They have no contribution to make. I had to close the committee sittings in their absence because they were not coming. And then when the bill returned to the floor, after they did not contribute constructively in the committee, they were not coming, I closed the business of the committee as chairman, brought the bill back from the committee, and they didn't even attend the session at which the bill was passed. That is the most important bill in Guyana. Everybody wants constitutional reform. They promised constitutional reform in their manifesto. And that is how they reacted to the most important bill, the constitutional reform bill. They asked for the hire purchase bill to go to the select committee. We took the hire purchase bill. When a bill goes to the select committee, you have to go through it clause by clause and put each clause up for discussion. We did that. Odesh Waldron The Minister of Trade and Tourism was chairperson of that bill, and she delegated to me the responsibility to go through the bill clause by clause, and I did it. You have to explain clause by clause. The bill had nearly 100 clauses. It took several months. Every clause was explained. They agreed. We made agreed changes. And when the bill came back to the Parliament, they refused to support it. They refused to support it after sitting for nearly a year in a select committee with that bill and agreeing clause by clause with the changes. And agreed changes were made. And when they come back to the Assembly, they didn't support the bill. We took recently the radiation bill, the single window bill. Those two bills, I must say, we had good experiences. We worked together and we produced the bill, and when the bill came back to the National Assembly, they supported it. But that's 2 out of 4. So I made that point. I give those examples to show you that we are not unwilling to take the bills to a select committee. But there are certain bills sometimes you cannot take because of time. But most importantly, certain bills do not need to go to a select committee. But the point is that they don't want it to go to a select committee because they can make out a case for it to go to a select committee. They want it to go to a select committee because they have not read it. And they want it to go there so that somebody will read it for them and explain what each clause means. Well, we are not prepared to do that in government. Not on every occasion. The Real Estate Agents and Brokers Bill. I thought that this was a consensual bill. I said in my presentation that I met with the 2 major real estate organizations in the country. And we had several sessions. And the bill was a consensual product of an engagement between the government and the 2 real estate organizations. I said all of that in my presentation. Lo and behold, when they began to speak, they claimed that they spoke with real estate agents and that the real estate agents were not supporting the bill. They said to my face that I lied when I said that I consulted with the real estate people and that the bill is a consensual product. I had to show photographs of the meetings that took place. They were all published in the newspapers. I sent out press releases of the several meetings I had with the real estate sector and how many persons attended. And these people standing with a straight face and telling me that those things didn't happen. And that they spoke to the real estate agents. And the real estate agents told them that they were not supporting the bill. Last Sunday, the real estate associations, the 2 associations representing all the real estate agents in Guyana, issued a statement congratulating the government for passing the bill. The statement was carried in the press. It says this, and let me read the 1 paragraph. The collaborative efforts between the Realtor Association of Guyana and the Guyana Association of Real Estate Professionals in partnership with the government of Guyana have culminated in the development of this significant bill. This is what the people are saying, the real estate people. Through a series of constructive dialogues and consultations with the Attorney General, each provision of the bill was crafted to encapsulate the perspectives of both associations, consumers and the government, exemplifying a true consensus-driven endeavor. I have it here. This is the statement that the people issued. Whose interests are these in the Parliament representing? I thought that they would be representing the real estate agents' interest. Whose interests are they representing in this country? And that's a worrying thing when you have your parliamentary opposition that seem not to be representing anyone. They're not representing their constituency, that's for sure. This is a sector-driven bill. They were not representing the sector. So are they representing their own interest? Miss Annette Ferguson brought some amendments to one of the bills. I asked her to withdraw the amendments from the inception because they do not make sense. You can't sit down the night before and try to draft amendments to a very complex bill and expect to get it right. So I went through the amendments, and from the floor, during the debate, I invited her to withdraw the amendments. I was not accusatory. I didn't get angry at that point in time. But then they started to persevere, and then I had to go into the amendments. The amendments did not make sense. They could not have been passed anyhow because they were not expressed in a coherent manner. An amendment must be clear in its language, and it must tell you what it seeks to amend. So it must say where in the bill it must be inserted, and then when you read it, it must make sense. It must flow with the rest of the bill. That didn't happen with the amendments. Somebody put together these amendments quickly, hurriedly. Some of them had nothing to do with the bill. One of them had a definition. They want us to insert in the definition section of the law, of the bill, the term, the Guyana Chartered Accountants Association. Now, you define a term in a bill that is used in the bill. So there's a definition section. So whenever this term applies or appears in the bill, you give it a definition. And that's what is called a definition section. It's normally labeled preliminary. So agent, if the word agent is defined, it will say in the bill, the word agents mean real estate agents and not custom agent. Broker means real estate broker and not custom broker. They want us to define, insert in the definition section, the Institute of Chartered Accountants of Guyana. But that term is nowhere in the bill. That term doesn't exist anywhere in the bill, so why are you defining it? As I said to them, cardiovascular surgery is not defined anywhere in the bill. It's not mentioned, so we didn't have it in the definition. But these things they pass over their head. And they were fighting down to have these amendments passed. One of the amendments was to change a quorum for a meeting. The whole of the meeting is 5. The constitution of the body is 5 persons. The quorum is 3. They want to change the quorum from 3 to 4. Does that even make sense? Does that make sense? That is the quality and caliber of presentation that you get from the other side. And I am saying that the people of Guyana deserve better. Their constituency, or constituents rather, deserve better. I hope that in tomorrow's sitting, we will have a better quality of performance from the opposition, because this is serious business. The bills that are going to be debated are very, very serious, are very, very important to the national development of our country and to the development and advancement of the people of our country. and the opposition, they have a role to play. So let me see what comments are being generated. Someone just explaining what they had to go through to get an account opened. And that regime was put in place because we lost corresponding relations with banks overseas, and our financial system came under scrutiny, and harsh measures were forced upon the system, and some of them have not yet been removed because they have to stay there for a period of time. Perhaps after we pass this mutual evaluation, we would be able to remove some of those very oppressive and onerous obligations that still are in the system. For example, in relation to the opening of bank accounts. I remember during the time when we were being sanctioned, persons when they, in the United States and in Canada, when they went to the money transfer places to send their money to their relatives in Guyana, they had to show source of funds. They had to show employment evidence. These things were not in place before. It is because the APNU AFC voted down those bills. That is what resulted in the unleashing of a menu of measures, because we became a place internationally recognized as an area that money laundering is taking place. That is what it meant when our national parliament refused to pass international obligations. It refused to pass laws that encapsulated our international obligations as a country. People all across the Caribbean and this hemisphere, in fact, wanted to know what is wrong with our parliament, because parliament across the hemisphere passed all these laws and our parliamentarians voted them down. I had to go to answer for Guyana at several conferences because people wanted to know whether our parliament was being controlled by persons conducting these activities. No one can believe or could have believed that these people were persecuting or prosecuting, if you wish, a political agenda when they voted down these laws. Anyhow, we have to move on. I have a series of questions from the press. Someone asked, what are the planned amendments to the Domestic Violence Act? Well, I'm pleased to report that the Domestic Violence Act will be completely overhauled. It's not going to be amended. It's going to be repealed and replaced with a modern family violence bill. A bill that is intended to correct all the deficiencies in the current Domestic Violence Act. The Domestic Violence Act was passed in 1996. At that time, it was a groundbreaking piece of legislation. 3 decades after, by the sheer passage of time, it has become old and outmoded. Significantly, after 3 decades, we have been able to see its weaknesses. Domestic violence, by no measure, has reduced in Guyana. The act, therefore, has been rendered ineffective. We now have to make a law of that type effective. The Domestic Violence Act was essentially a legislation in civil law. The new bill will have both civil and criminal remedies. Nobody went to jail or could have gone to jail under the Domestic Violence Act. It was not a criminal statute. You would have gone to jail if you violated one of the civil orders. So you had order to put the man out of the house or the woman out of the house, an order to restrain a particular activity from taking place, but no sanction, no offenses of a criminal type. One had to go back under the ordinary criminal law to charge for assault, wounding, etc. Now, it will be a different type of legislation. Persons will go to jail for domestic violence offenses. Persons will be kept in custody rather than be restrained from going into a house or the matrimonial home. They'll be locked up. They'll have orders of that type to keep the abuser away from the victim. You don't have that now in this law. And this law, this new bill that we are working on, we took a lot of provisions also from the United States of America. So it's a different type of legislation, very penal, very harsh, because the problem that it is intended to address is one that is oppressive, one that is serious, and one that has resulted in a tremendous amount of violence, death, sufferings, breaking up of families, and a whole host of pain and anguish. And you have to get a law that is strong enough to respond to that type of social problem. And as I said, it is as prevalent in Guyana as it ever was. So this new law, hopefully, will deal with it. But one law can't deal with this situation. You have a multiplicity of things that we are working on. For example, that brings me to the next question about the work that is being done currently to study, to interrogate, to investigate the causes of gender-driven homicide. The terms of reference are being prepared, and expression of interest would be invited from suitably qualified persons to undertake this survey or this study, if you wish. Examine over the past 10 years deaths that have arisen from persons who have familial relationships, not familial relationship, but spousal relationships, and examine what may have been the causes and accumulate that kind of data. Ethnicity, age, geographic location, societal factors, socioeconomic background of the persons, all the surrounding factors that could inform the establishment of the possible causes, Because only when we can examine the causes of a problem that we can really begin to address the problem. And I believe that that needs to be done. And under the criminal justice, under the Support for Criminal Justice project, this initiative is being commissioned. And the result of this, hopefully, will also inform the family violence bill that we are working on. That is why that law will be one that would be informed by empirical data, past experiences, etc. It is not going to be a sterile initiative or law reform. It's going to be driven by and informed by actual studies of cases and the new provisions will be informed by the inherent and structural revealed weaknesses of the current law. For example, I know of a case where the domestic violence order was made by the magistrate. The magistrate made the order to exclude the man from the house. The man had the order in one hand, and he had a cutlass in the other hand, and he went and he chopped his wife. I believe she died subsequently. So it's not that the court didn't grant the order. An order was granted. Now that law has been rendered completely useless in that situation. The order was not worth the paper that it was printed on. Those types of incidents will inform what will the new law will contain. That's the point I want to make. A question has been asked of me whether the families affected by Madhya Dorm's fire have received any payments. Of course they have. I reported that already, I believe. They got a deposit of the sum to which, a deposit on the sum that the government is offering as financial assistance. That was paid to them in cash, and the balance the balance of those payments are being now processed so that they can be fully effected in the very near future, within the next 2 or 3 weeks. How many families signed the agreements? On the 3rd of July, I have some jottings here. 20 of those agreements were signed, and then on the 31st of July, 11 was signed. 11 was signed on the 31st of July and the 1st of August, and on the 3rd and 4th of July, 20 were signed. And that was the number of agreements that we had to sign based upon Cabinet's decision. So all the agreements were signed. Someone asked whether the supplementary paper that will be debated in Parliament tomorrow has provisions for this Madhya fire. I think so. I'm not sure. Don't hold me to it. You will find that out tomorrow. And the last question is, someone asked on what basis, what the legal ground that the President was able to extend the tenure of the Commissioner of Police. The law provides for the President to extend the tenure of a Commissioner of Police or any person performing the functions of that office. Utilizing the provisions of that law, the President, and following the procedure outlined in that law, the President extended the tenure of Mr. Clifton Hickins to a date to be determined. I assure you that it was lawfully done, and the basis and grounds for it exist in the laws of Guyana. So this is where I've come to the end of tonight's discussion. I want to thank you very much for staying with me over the last hour or so. I believe that we have covered a lot of grounds, and I invite you to join with me next week as we continue to discuss the important events that would have taken place in Guyana over the past week or so. Join us tomorrow in Parliament. We are starting at 10 a.m., as I said. We have a packed day, a very important public business to discharge, and then after that, Parliament goes into a recess and will resume until, I believe, October later this year. I thank you once again, and please enjoy the rest of the evening and stay safe for the rest of the week until I see you next week. Thank you.